Upon America's entry into the First World War in 1917, Congress began to pass laws to counteract the possibility of enemy spies working to destabilize the war effort with the Espionage Act of 1917. This act made it a crime to cause insubordination, disloyalty, mutiny, or refusal of duty in the military. It also made it a crime to obstruct military recruiting. Charles T. Schenk, a socialist from Philadelphia, began to print flyers that encouraged people to write their congressmen and assert their rights against being drafted into the military. He claimed conscription was unconstitutional and wanted more people to oppose it by spreading his flyers. He was convicted of violating the Espionage Act for doing this in 1917. The Supreme Court agreed to review his case in 1919. The constitutional question at hand: does the Espionage Act violate the First Amendment's free speech rights?
Yes, please, now, go at you two. Yeah. Yes, this will be very interesting indeed, yes. Yeah. Well, you see, the First Amendment specifically prevents Congress from punishing people for criticizing the government. Schenk was simply sharing his opinions, nothing more. He did nothing wrong.
You are mistaken. Schneck's flyers were in clear violation of the Espionage Act. He was attempting to obstruct military recruiting. His flyers presented a most dangerous threat to the recruitment of new men for the war effort.
Listen! The Espionage Act itself is unconstitutional. The First Amendment clearly conflicts with it. How can Schenk be punished for exercising free speech? It's truly unspeakable. A real tragedy right here in our own nation. Oh, how has it come to such a thing? Has democracy been snuffed out before your very eyes?
You fool. You understand nothing of military matters. You see, during wartime, the government must be able to exercise extra powers. Yes, the government must be able to ensure our safety at wartime. And, unfortunately for you, that means limiting your free speech.
You are a stain on the face of our democracy. Yes, well, I'm afraid we are all out of time. What a show, what a real spectacle this one was. I will come to a decision once I discuss this with my brethren.
The Supreme Court unanimously decided in favor of the United States. Justice Oliver Wendell Holmes explained that usually the Espionage Act would be considered unconstitutional in a peacetime situation, but the context in which the law passed significantly mattered to the case. Due to the wartime environment, the government is able to exert laws which infringe on freedom of speech in order to aid the war effort. Justice Holmes also created a new test which would be used in future rulings which considered the question of free speech. This was the clear and present danger test, to help distinguish which forms of free speech were protected under the First Amendment. If someone uses their speech in a manner that causes a clear and present danger, such as the famous example of yelling fire in a theater, this is not protected by the First Amendment. The primary takeaway from this case is that during a wartime environment, the United States government has extra powers which allow it to limit the freedoms of citizens in order to maintain security during the war. Comparison case: Texas v. Johnson. In 1989, a man named Gregory Johnson set fire to an American flag during a demonstration against nuclear weapons. He was convicted of breaking a Texas law that prohibited the desecration of American flags. The case went to the Supreme Court, where the justices ruled in a 5-4 majority that the burning of the flag was protected by the First Amendment, as it was an act of expression. Notably, the ruling was different than in Schenk v. United States. Reasons for this is because the Espionage Act specifically aimed to help the military in the war effort, whilst the laws burning the flag did not contribute to any such goal. The United States was also not at war in 1989 when the court heard Texas v. Johnson, contributing to their decision.